It is Monday, February 19th, 2024. It is also President's Day, which I think is relevant. And I want to share some footage from the Fani Willis hearing. And I'll be doing this as often as something relevant comes up that people need to consider. And in this particular clip, the privilege that they're talking about is client attorney privilege, whether or not he has to disclose any particular information. So let me set that up. The other thing that I want to mention is that the sound quality is very muffled. So I put on YouTube closed captions to try and make what is being said clear. But the most important reason for me posting this is that I have tried to explain to people that the way the judicial system is supposed to work is that the burden of proof always falls on the accused. The accused has to prove that what they are being accused of is false, which is why I always said I was so confident about being able to sue the president, because of the way I have worded the complaint. But I am so grateful that in this clip, the defense team who has brought this allegation against Fani Willis not only demonstrates how this process has been reversed, but they openly complain that they have to do things that they feel like they shouldn't. But I don't think that they fully appreciate how long they have used this reverse method of the judicial process and have caused people to be falsely convicted. I got cut off. Falsely convicted or falsely fined or charged civilly. So let's take a look.
Your attorney, B.C. Chopra, was there, and I was there, and another attorney, Burt Cohen, were there, correct?
Those people were there at the time. B.C. was not my attorney. I didn't realize I needed an attorney until I was subpoenaed.
But B.C. Chopra was there.
I can object to the documents.
Ms. Cross, as I see this line of testimony, much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this, and she should be sanctioned. And I think she's laying it down. Okay, all right, Ms. Merchant.
I recall it was in a conference room in the front. I don't know. I know you were handling a case in Judge Harris. I think I was speaking.
All right, as we continue on, I want you to take off your court TV hat, because most people do not understand the legal code that they are trying to use. But I want you to put on your moral cap and appreciate that what the defense is trying to prove is that Fani Willis should be disqualified from prosecuting the case against Donald Trump to hold him accountable for election fraud in Georgia. So it's really about her capacity to be able to do that. And yes, there are certain things that prosecutors are expected to do and guidelines they're expected to follow, so on and so forth. But I want you to consider the question, is she qualified and responsible enough to be able to prosecute this case ethically? That's the real question here, okay?
And what day was this?
It was
September 14th, correct.
And I sent you a screenshot of a full county overage records request I did.
Yes, and I said, wow.
And then we continued to text.
Wait. And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with a circle around it, and I did not respond.
Okay.
All right, thank you.
All right. Mr. Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you, sir.
actually, I have an additional
Okay.
thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, it is true, accurate, and complete, and perhaps we can see it on Mr. Bradley's phone. But more importantly, I am going to object. I understand, of course, the way that Mr.
Sure.
was able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I don't.
Sure. And so am I, Ms. Merchant. I'm not seeing so much of
But I'm concerned about going into the content of the statements without putting things in the buckets that I don't.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me, and I think we're on track with that. Were you planning to tender these text messages?
I was planning on discussing them with him. Now, if yesterday he said we didn't talk text about this case, so that was his testimony again today, then yes, I will at least I would show them to him to refresh his recollection or to impeach him. But their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history with Mr. Bradley,
And you know that there is.
if they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to just lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So
Right, because you want to be on the record in case somebody wants to bring action against you.
So I asked him about one question, and he read
Sure.
on the second
Why
one.
don't we just go with your next question and we'll see where we go from there.
But, so,
Apparently, when you wait for her to ask a question.
and I understand that, Judge, and I'm not
Well,
trying
apparently
to
you don't, sir. Wait for her to ask a question.
All right, he
You'll
not.
have a chance.
Scott McAfee ain't playing no games.
So I think the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about them.
Some text said yes.
Yes, okay. And then you called me again on September 15th, 2023, and you spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And, you recall the following Monday, Your Honor, I appreciate the question, as it is on the form, and if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer the source of information, and I feel like it is so inflammatory as to say out loud, without knowing where Mr. Bradley.
Which is important because she wants to impeach his testimony or be able to impeach his testimony.
Why is it that we're not allowed to ask a question, and then when the question is asked, there's an objection made either by the state or the lawyers for this witness?
How does it feel?
What the state would like to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why they get to do that, and we are obviously in the same position to say to them, tell us every question you're going to ask first. I realize it's a privilege, but that can be the questions asked, state objects, Chauffeur objects, in the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial, I don't think that, I'm just suggesting.
Sure. So, Mr. Stan, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say, and that puts us in kind of a different posture in that respect.
That's right.
Have some sense of what's going to come out. But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that you wouldn't be in a
Sure.
Objecting and having 4 different lawyers talk about privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that objection to the question again. We gave a state opposite as well, trying to be completely transparent. I also I have to establish that his statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that was said under oath yesterday, and that I did not get this information. And so I have a right to.
Which I've already said we can do and we can go over. But
CYA.
and we've already started doing that. But the next question, as you plan to ask it, may presuppose again some information that he has that we need to determine whether it's inside or outside privilege. Is that right?
No. Well, I don't believe so. No. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege. If we're going to talk about privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying to carefully craft something to avoid that. But happy to
I think she said carefully, not fearfully.
I don't see a way around that, Ms. Cross.